In our previous segment, we outlined America's basic political structure: two parties, Democrats and Republicans, competing through elections to control executive and legislative powers. The Supreme Court, as the highest judicial body, acts as a referee, Constitution in hand. To summarize the positions of America's two parties very simply: Republicans defend states' rights and advocate for bottom-up governance. Democrats favor expanding federal power and support top-down governance. In judicial terms, this means justices appointed by Republican presidents tend to advocate judicial restraint, preferring minimal federal legislation and avoiding interference with states. In contrast, justices appointed by Democratic presidents tend to support judicial activism, believing outdated and reactionary state policies should be swept away through federal legislation like a broom clearing dust. Otherwise, how would society progress? The arguments among the 9 Supreme Court justices primarily revolve around this fundamental difference. Now, let's return to the main theme of the oath and discuss the Supreme Court. The 9 Supreme Court justices serve lifetime appointments. This design was intended to free justices from political pressures once appointed, allowing them to rise above partisan disputes. However, they are nominated by presidents. So while justices don't need to show party loyalty after appointment, they were initially nominated because their ideological views align with the president's. Therefore, to some extent, the Supreme Court still reflects partisan tendencies. When Republican-appointed justices dominate, the court tends toward judicial restraint. When Democratic-appointed justices form the majority, judicial activism prevails. The same-sex marriage ruling provides an excellent example of this tension between judicial restraint and judicial activism. On June 26, 2015, the Supreme Court ruled 5-4 that state laws prohibiting same-sex marriage were unconstitutional. This meant states could no longer ban same-sex couples from marrying, as the court determined such bans violated the Constitution. The 5-4 vote reveals how deeply divided the justices were. Where was the divide? Democratic-appointed liberal justices believed that states still banning same-sex marriage were utterly backward, and the Supreme Court needed to intervene to prevent states from brutally interfering with LGBTQ+ rights. Republican-appointed conservative justices argued that marriage falls under state jurisdiction, beyond federal control, and that diversity among states should be respected. Conservative Justice Scalia, after losing the vote, publicly complained. Before this ruling, 37 of America's 50 states had already legalized same-sex marriage. In the remaining states, same-sex marriage advocates continued to appeal and lobby. When they lost, they accepted defeat gracefully and persisted in their efforts to win the next time. This exemplified American democracy at its finest. This is how our political system is supposed to work. Clearly, Scalia wasn't primarily opposing same-sex marriage itself, but rather judicial activism. Judges overstepping their boundaries and taking on responsibilities that should belong to Congress. This ruling led to several problematic consequences. First, just 3 years earlier in 2012, Congress had passed the Defense of Marriage Act, which specified that the federal government would never recognize same-sex marriages. When challenged, the Supreme Court ruled 5-4 that this act was unconstitutional, specifically because marriage falls under state jurisdiction and the federal government cannot interfere. Isn't this showing bias? When Congress prohibits recognizing same-sex marriage, you say it's unconstitutional because the federal government can't interfere with states' marriage laws. But when states prohibit same-sex marriage, you also call it unconstitutional. So what exactly does the Constitution say? Government policies changing overnight isn't necessarily catastrophic. But in the judiciary, especially in America's common law system, consistency in rulings is the most treasured principle. The same-sex marriage ruling damaged this consistency, severely undermining the Supreme Court's authority. That's the first issue. Second, as Justice Scalia noted, 37 of America's 50 states already permitted same-sex marriage. This was an urgent matter. If same-sex couples needed to marry, they could simply relocate. Having different policies in different states embodies the very essence of a republic, protecting regional diversity. Chief Justice Roberts further noted from a personal perspective that in the remaining 13 states, LGBTQ+ individuals previously had opportunities to gradually persuade their neighbors to change perceptions and gain understanding and support. Now, with this sweeping ruling forbidding opposition, same-sex couples can marry but have lost a chance to integrate with others. As a minority group, LGBTQ+ individuals may find it harder to overcome exclusion and hostility. In some ways, they've actually been disadvantaged. Third, the Supreme Court should function as society's brake, not its accelerator. By supporting LGBTQ+ rights in such a radical manner, the court angered America's large Christian population, particularly evangelical believers. Protestants were traditionally not very active in politics and somewhat indifferent to rights issues. But with the Supreme Court taking such radical steps, they felt compelled to participate in voting. The oath dedicates significant attention to another case, how Obama's healthcare reform, on which he had staked all his political capital, managed to pass Supreme Court review. This case also highlights the conflict between judicial restraint and judicial activism. The core of Obama's healthcare plan mandated that American citizens earning above a certain threshold must purchase health insurance or face fines. Low-income groups would receive government subsidies, with the goal of ensuring everyone had health coverage. As soon as the bill passed, 26 state governments immediately sued the federal government, essentially saying, "Who do you think you are? You can force individuals to buy something now? What's next? Mandating we buy broccoli twice a week. Vegetables are good for health and would reduce medical costs, right?" In response, Obama administration lawyers argued before the Supreme Court. When you don't have insurance and get sick, hospitals still treat you. If you can't pay and walk away, insurance companies lose money. This raises premiums for everyone else, effectively making others pay for your medical care. But with broccoli at the supermarket, you can't take it without paying. Your broccoli costs can't be shifted to others. So health insurance and broccoli aren't comparable. This explanation was indeed excellent. But the premise, I can force you to buy something because it's good for you, is genuinely frightening. Once this door opens, there's no closing it. Conservative Justice Alito pointed out that following the government's logic, the funeral industry works the same way. If someone like Bob never saves money and has no friends or family, when he dies, others end up paying for his burial. So shouldn't the government force Bob to buy coffin insurance while he's alive or face penalties? You see, the U.S. Supreme Court is a temple in every American lawyer's heart, arguing a case that can bring honor to one's entire family. Yet even in such a prestigious setting, they debate using examples like broccoli and coffins, which is quite fascinating. At that time, the Supreme Court had 5 Republican-appointed justices and 4 Democratic-appointed justices. Logically, Obama's health care plan shouldn't have passed since Democratic justices were in the minority. But in this case, Republican-appointed Chief Justice Roberts defected and voted in favor. He understood that Obama had staked all his political capital on this case and couldn't afford to lose. Roberts decided to make a political deal, giving Obama a pass on this case in exchange for Democratic justices' support on other cases. More importantly, he wanted to avoid excessive tension between the Supreme Court and the government. Republicans were furious about Roberts' betrayal. Not only did it dash their hopes of delivering a crushing blow to Obama, but what was even more outrageous was a political calculation behind Roberts' defection. A justice can be many things, but never a politician. This was Roberts' most unforgivable action. As mentioned earlier, Democratic-appointed liberal justices advocate for judicial activism, intervening whenever possible. Republican-appointed conservative justices favor judicial restraint, avoiding intervention when possible. Judicial activism was most pronounced during the 1960s when Earl Warren was Chief Justice. Ironically, Warren was also a great betrayer, having been nominated by Republican President Eisenhower. Eisenhower never imagined that after becoming Chief Justice, Warren would completely abandon judicial restraint, using the Supreme Court as an accelerator and causing revolutionary changes in American society. Eisenhower later lamented, "Nominating Warren was the biggest mistake of my life." During Warren's tenure, the Supreme Court made tremendous contributions to racial equality, protecting vulnerable groups and defending freedom of speech, powerfully driving American social progress. The problem, however, was that these advancements should have been achieved through congressional legislation, not decided by a few justices banging their gavels. In other words, the Supreme Court shouldn't have stolen the spotlight by taking legislative power from Congress. This damaged the foundation of America's separation of powers, a major problem with judicial activism. Additionally, as mentioned in the same-sex marriage case, while legislative methods accelerate social progress, they also create hidden problems. Without democratic procedures and extensive debate among different parties, the reforms pushed by the Supreme Court lack broad public support. This creates divisions between different ethnic groups and social classes. Even today, American society continues to pay the price for these social divisions.